So good morning, everybody. I want to welcome you to our EPL webinar. As you know, we've been doing a series of different webinars really to focus on prevention. Obviously, right now it's a very difficult time, but we're always wanting to educate and provide resources to all of our clients and all of our prospective clients as well too. I'm very, very excited to have Patrick with us today from Rubicon Insurance Services. He is the expert when it comes to EPL. He's going to give us some best practices, what's happening right now in California, and also to some recommendations as well too. For those of you that have questions and some issues, if you want to keep those, you can put those in the chat and we will respond to those at the very end here. Also too, Patrick was nice enough to put on the handouts a quick overview of some of the talking points as well too. But Patrick, welcome. Thank you so much for being our guest here today. I know that being that we're in business insurance, we sell a lot of insurance. The goal for us though as a brokerage firm is to provide the absolute best policies, but at the same time, provide all of our clients with preventative measures so they don't have to use the insurance as well too. So thank you so much for coming on, kind of giving us best practices, what's happening, what you're seeing in the industry, and also too, maybe we can take a look at some policies to make sure that people have exactly what they need to have during this difficult time as well now. So thank you so much, Patrick, and I'll hand it off to you.
Toby, it's a great pleasure to be here. Thank you very much, and thank you everybody for coming along. I mean, what happens with insurance is what Toby said is insurance as a tool in the early days was used as a resource of last resort, where if something cataclysmic happened, would bring in the insurance. Over the years, what ended up happening is a lot of people thought, well, if we need a little maintenance with our company or with our car or our house, if something gets a little weathered or is slightly damaged, let's put in a claim, because the deductibles started coming down and costs were low, and you could use it more as a maintenance as opposed to that cataclysmic resource for the rainy day. And over the years, claims have been picking up and costs of claims have been rising. And now that we have very major catastrophes with wildfires in California, we've got other legal actions happening throughout the country over the last 10 years, that insurance carriers are writing bigger and bigger checks, and they've been forced to charge higher premiums. And another thing is, to avoid these maintenance related claims, their deductibles are going up, so much so that some policyholders can't even afford the deductible, let alone the premium. So there are trends happening, and so we want to bring a focus to that in one particular line of coverage, which was employment practices. And as news of potential vaccines have just broken in the last week, I think it's confident we can say that we are now at the end of the beginning of the pandemic, and we can start looking forward. But a lot of questions come through in the insurance industry is, okay, well, what's the impact of COVID, with businesses in insurance, specifically with regard to employment practices? And so, that was where Tony and I had the conversation was, what's happening with COVID and just overall, because California has been a hotbed for legal activity. What's going on and what can we look forward to? So to start off with employment practices, let's just see where trends are right this second. Now, again, employment practices are exposures that employers face every single day because they're involving people that work at a workplace. But I mean, unlike customers, you may be seeing these same employees every day. They get annual reviews, if not earlier than that. You're constantly hiring people. Sometimes people have problems in the workplace, just family problems, and we can see with COVID just overall stress and tolerance levels are exacerbated now. So you're dealing with this exposure all the time, and so it's unlike other types of exposures in business. This is one that's probably the most pervasive, frequent exposure that employers face. So you got to pay attention to it. And naturally, we're having a lot more incidents happening. But to give you an idea, just the scope of them now, your average claim is going to take you about 275 days from initial reporting to finally closing it. I mean, that's a big chunk of your life out of there, let alone the distraction from the workplace. But you're looking at well over 3/4 of a year that an average case goes on. And the average cost is now up to $125,000. That's for legal expenses, ultimate settlement. That does not include any other lost opportunity cost, cost of distraction, other things that employers are facing. So employment practices related suits, and these are for discrimination, sexual harassment or harassment other than sexual harassment, failure to hire, wrongful termination, and retaliation acts. Those are all contributing to this, okay? We went and did a survey real quick with the insurance carriers on just what the top 10 EPL actions are in terms of discrimination. It's still early in the game to get viable information on COVID-related actions, and I'll talk about that. But you know, your discrimination charges are the ones that we've been seeing before. It would be race, disability, sex, national origin, religion. You know, one thing that's coming up now is maybe somebody isn't fired, but they're moved to another position or a less favorable work environment, either schedule or what have you. And you'll have people that say, well, you're retaliating against me, you're punishing me. That's retaliation in the notes. There's a lot more of that happening now with the EEOC than even race or gender claims right now. The newest action out there is just a reflection of increased technology and increased sensors and information that we are collecting, and that is genetic information. There are, as we're moving to with technology, biometric type markers and identification means through either the iris or a thumbprint. Those types of issues can bring up privacy issues, and so we're beginning to see some of those coming. That's probably the newest type of case that's action happening right now, are genetic information type claims. Now that's just in the bucket of the discrimination related suits. Far and away, wage and hour allegations of failure by the employer to pay proper overtime, misclassification of employees. Those two, wage and hour and misclassification of employees, where are they independent contractors or are they full-time employees? Those are the areas that have by far the most number of cases being brought, okay? And they're straightforward, they're easy to prove and easy to go after, which is why many insurance carriers have stopped even defending wage and hour related cases. And while they will, the way they address this is if you terminate an employee and they turn around and sue for wrongful termination, and in addition they add an allegation that I worked during my lunchtime or you refused to pay me overtime that I earned, those additional little actions, okay, and complaints within the scope of a wrongful termination overall claim can be addressed and covered by the insurance company, okay? Now, the caveat is that the insurance company they will provide defense costs to help the employer argue against that allegation of unpaid overtime. But if it's determined that, yeah, the employee worked 50 hours of overtime that you miscalculated, the employer is going to have to pay that. The insurance company is not going to pay wages that should have otherwise been paid, okay? But they will at least defend the case. What is happening though is if you just get a pure, and we've had a case once with wage and hour where an employee was terminated, they made a complaint saying my overtime, I worked during my lunchtime and so forth. That was addressed and was defended. However, that terminated employee had two other friends that didn't get terminated. They heard about this and they brought their own individual actions for failure to pay overtime. The same employment practices policy not covered those because pure wage and hour, it wasn't related to another wrongful employment act. Okay, there are one, maybe two insurance companies that still will provide coverage for that second scenario where it's just a pure wage an hour, no other wrongful act alleged. There are two or three. Again, all they are going to offer is the cost to legally defend the employer in the action. They will not pay if it's determined that wages should have been otherwise paid. So those are a couple things out there. Employment practices is also impacting mergers and acquisitions. Our firm has a huge practice in M&A activity where one company is buying another company, and the target company on these acquisitions better have their HR policies and procedures in place. If they have, issues on employment practices, that could hold up a merger in and of itself. In the old days, you would think that, well, there are financial concerns, there are big outside legal issues, intellectual property concerns, things like that. No, you could have just a very angry, disgruntled young person that's not being transitioned over as part of the merger, and they sue for sexual harassment or discrimination, and it could completely derail an M&A deal. So, employment practices as an exposure is not just limited to the employees. It could have devastating impacts out there. Now, the dynamic that's been happening is, as a lot of things, things are getting more expensive, costs are going up, deductibles are going up, which then means that coverage is coming down. What's causing that, particularly in California? Okay, well, a lot of people are pretty familiar that California is a plaintiff-friendly environment in terms of litigation. It is employer-friendly, particularly in the courts with juries, but not only with juries, but with Department of Labor, Department of Fair Employment and Housing in the state of California. Everything is skewed and leveraged in favor of employees over employers. So you've got a real challenge there, just as employer with those types of exposures. Okay. The other issue is that state of California in 2020 is going broke. Okay. They have to find any way they can to collect and charge revenues. And what the state is doing is fees to file claims, to respond to filing, any other legal things what you're doing either with the Department of Employment and Housing or with the courts. All those fees are going up. Okay, and so in tandem with that, attorney's fees in the state of California are going up, okay, because it costs a lot just to file a response to an action. It costs a lot to engage an attorney to respond on your behalf, and all of those are combining to having a simple claim being 2 or 3 times the expense as similar claims brought in other states. The other issue on here in California, I mean, we all love the climate here, and we are all subject to what we call the sunshine tax. And to live in a moderate climate like this, costs are up. And the cost of living in California, as everybody knows here, is exorbitantly high compared to other places. Okay, well, if the cost of living is up, that means that payroll is up. You are paying employees in California substantially more than you would pay them elsewhere. Therefore, when these employees lose their jobs, okay, their basis for a demand for damages is 2 or 3 times the amount they're going to be demanding in other states. And so you've got an expensive place with folks that expect more money to live, and therefore their demands are higher. And then the cost to fight those demands or defend against those demands are higher. Okay, and so we are now seeing average retentions on these policies going from 10,000, 15,000 to 35 and 50,000, sometimes higher, which is very problematic, which I'll talk about in a little bit later on now. So a common question we're getting right now is, well, what are you seeing with COVID? I mean, what trends, how has this impacted employment practices? Right now, it's been a little bit limited in terms of claims. Again, I mentioned earlier, it is still a little bit early, but it's tough to claim discrimination or wrongful termination if a small business is having to let everybody go. Okay, so there hasn't been right now preliminarily an uptick in the number of claims or the types of demands as related to COVID. Okay, Where we're seeing an impact for COVID is in the underwriting side. Okay, so what in the old days, you go fill out your employment practices application and send it in, you get your quote. There are additional questions that are now coming in. Okay, and these include, are you anticipating any layoffs? You know, as related to COVID, you know, do you know about anything like that? If you do, report it to them, and they're going to see what kind of thing can be worked out, because that's a known event, and underwriters want to deal with known events before they have to cover them. The other area that employers are going to have to show is financial sustainability, because in the past, employment practices didn't really require an employer to provide financial statements. That is now a new requirement that we're seeing. And it's very simply because in the wake of COVID, with a lot of business closures out there, even though we haven't seen a spike in claims, underwriters are concerned that, well, if a company is not financially viable, are they actually going to make it through the policy term? I mean, can they pay the premium? More importantly, if they do have a claim, can they even afford the deductible? And that's become a real problem, which brings me to the next thing. And, you know, when we've got these, we got that slide there, Tom, so we can go to the next answer. So, you know, so we've got all these costs coming in when the claims are going up and premiums are going up, but premiums still aren't necessarily keeping pace with the claims. And so, you know, these defense costs are coming up. You know, what's happening? Why is that happening? And there are a couple of dynamics here. One of the things you have to look at is you have to look at how cases are tried and how you know, complaints are handled on the legal side, and compare it to other things. And so, in talking with the employment practices insurers and the claims folks over there, you know, when we ask them what's going on these claims, real simple basic thing that people don't realize is that cases are really tough to get dismissed. Okay. And the reason for that is, if you bring an employment practices thing, it's a matter of fact. And let me compare it to other cases or other complaints that are brought, because this is, you know, top of mind right now. Is, let's compare this to the allegations of voter fraud in the election. Okay. There are complaints or allegations of voter fraud, and they're being presented to judges, and judges are turning around, and a lot of them are being dismissed because the judge says, do you have evidence? What is the fact that you have that there's a matter of fact that fraud occurred? Show me where that is. Okay, that's a high bar to set, and it's causing a lot of these actions to get delayed or completely dismissed outright. Well, with employment practices, if somebody has been fired, that's a fact. Okay, all they have to do is point to, on, you know, November 1st, I was let go, and that is a state of fact. You can't immediately dismiss it. Now, they will argue, well, I was discriminated against. That's what caused my termination. They were profiling me. They were, you know, committing, you know, retaliation against me. That's why. Well, the fact is, you got that employee got fired, and you can't get around that. So then the case can't get dismissed, means it's going to go on, meaning now the meter on defense costs and expenses and court fees starts moving. So that's one of the dynamics there. The track record right now in LA County, which is probably the most surcharged region in the country, even more than New York, by employment practices, is that 98% of the cases in LA County get settled. Okay, they don't go to trial. Okay, there's no way an insurance company wants to risk that. I mentioned earlier that you have both the environment in California is very employer friendly out in the public. It is also very employee friendly in terms of the regulators and the government departments and so forth. And so when you've got those elements going against you, you really don't want to put a question or a lawsuit, you know, in the hands of a voter where it's not even as lucky as 50-50 with flipping a coin. Okay, and so we're seeing, you know, that impact happening more and more as settlements rather than when that happens. Now, here's where the problem comes in. Is you want to go ahead, you've got a case, let's settle it, let's pay them $100,000, let's get out of this. Okay, here's the problem that's happening, is that while the insurance company can cover their part of the loss, okay, and they're ready to cut the check, policyholder can't. They can't cover the deductible. And that's a real problem, because then the insurance company, if it's $100,000 settlement or overall cost, and there's a $50,000 deductible, the insurance company is only going to be cutting a $50,000 check. That means the plaintiff is going to be coming after the employer personally, and that's a real danger. And so the concern is that employers are saying, look, I can't afford the premium. Let's raise the deductible. If we can't get the premium down a little bit, let's do that. Well, that's going to be a little bit counterproductive if you can't withstand the retention. There are very rare cases, I mean almost no cases, where the insurance carrier is going to sit there and say, well, we paid half. I know you can't pay half. Why don't we cover some of that for you? That very, very rare. Do not count on that happening. And so as options come in for coverage and so forth, keep in mind that, you've got sizable retentions that are, again, we're averaging $35,000 to $50,000 in your average EPL retention now. This is probably no better time to emphasize any kind of preventative, proactive work with HR consultants, which Tony can talk about, and other attorneys, not the insurance company attorneys, but HR and labor attorneys, to come in and just get you set up and prevent these things from happening. Because if you spend $10,000 to $15,000 over the course of a year for preventative measures, that's going to save you at least $20,000 plus if an incident happens with a claim and you got to pay a retention. So we've got these situations happening. Well, what are the insurance companies doing about this? Okay. And what they're doing is they're being very proactive, and they're taking charge in claims. Now, let's go over a couple things. First of all, and this is common sense, but you'd be shocked how many times there are employers that try to take care of these situations themselves or handle it in-house, only for it to blow up. In the event that there's an incident out there that an employer or supervisory employee becomes aware of that could lead to an employment related claim, the insurance company needs to be notified about that as soon as possible. We'll make a recommendation on what you do with the insurance policy at the end of this, but notification at the earliest point is critical, because the sooner the insurance claims people can get involved and assist with a response, the better off it is for everybody. And not only that, it's there is no financial impact in terms of rating on future policies if you report a bunch of incidents and they end up not going anywhere because they were handled. They don't get held against you. Unlike the perception out there as well, if I put a bunch of little claims in for denting my car insurance goes up. Okay, well, that happens on maintenance related claims. On employment practices, you could put in many notices of incidents, and if they never lead to anything, it's never held against you. So you have nothing to lose by getting something on the record, and then later on it can get closed. So the soonest you can have that, the better. Here's the other way that a lot of people don't realize with regard to insurance policies and how they're written. Most EPL policies are written on what we call a duty to defend basis. What that means is, and it's in the general terms and conditions of the policy, but what it says is the insurance carrier, once they have been notified by the policyholder of an incident which could give rise to a claim, it is the insurance carrier's duty by contract, by law, that they must defend their employer, their policyholder, whether the claim is false, fraudulent, just a waste of time, whatever. They are on the hook to provide a defense. Okay, they can't make a decision unilaterally and say, we don't want to cover this, we don't think it's anything, it's a nuisance claim. They can't do that. They must defend you. So that's kind of nice. You've got the peace of mind as a policyholder that, hey, I've got these guys have my back, they're going to step up for me. Okay, there's another caveat to that. What that means is that the insurance carrier has the sole authority on picking an attorney, taking a strategy to address the defense of the case, and to move forward with it. There are a lot of employers out there that have their own business counsel, and they'll insist on I want my business counsel who has a labor attorney, they're really good. I want to bring them in. They know me, you don't. And so I want to bring in my attorney. Okay, insurance carriers, if they allow that attorney to work, that'll be fine. They just won't pay them. And that's kind of what you need there. And so if you're notifying an insurance carrier about an incident at an early space, early point in this action, discussions can happen with, okay, how do we coordinate the defense? If I spend $10,000 on my attorney, is that going to be applied to my $50,000 deductible? In a lot of cases, it's not. And so it's essential that you get on the same page with the defense counsel at the insurance company. And then they can go ahead and set up strategy to defend you. And I really want to stress this. If there's one thing I want to stress is that the claims people at the insurance carriers, okay, and the attorneys that they assign, their objective right now is they are not here to save money for the insurance company. Their objective is they want to get this right. If we've got an action here, how do we get in, get it dealt with, and see if we can avoid a $100,000 claim? Again, the average is $125,000, but I don't want that $100,000 claim becoming a $600,000 claim. And if we can find a way to get a resolution sooner rather than later, all the better. And that's what they do, because they really want to get it right. They want the employer, the policyholder, that's their client. They want them to be able to move on with their life, move on with their venture, unencumbered by these things hanging out. So it's one of those issues. They're not looking to scrutinize on keeping costs down as much as they are on getting this thing right. And again, the longer these things take, I'll point that out at the end, the longer they take, price only goes up. Now, one of the issues that comes out, and there's a role that as brokers place in this, is because we are the conduit between the insurance carrier and the policyholders. We want to make sure that the communication lines get through. There are a lot of times, rather than risking a trial or other confrontational adversarial area, mediation or some kind of settlement forum is probably the most favorable path to go. And so you're going to have a lot of us come in, just so you know, recommending and working with you on going into some form of mediation so that you get reduced costs with courts, because there's no court involved. It can get resolved and you can move on at probably the fastest possible way. And so it's a responsibility for us to hear the side of our policyholder and get out there and see if we can find a mediation and so forth. But the strategy for us right now is going to be settle as early as possible, because the longer it goes, demands may over time come down by the other side, but then costs go up. It's just, the idea is let's settle as soon as we can so that we can go forward. And this prompts a new, mindset, because if you fail to settle and you want to go forward and fight it, and you have every right to fight it, there are a lot of outcomes that people don't think about that could happen that will all of a sudden sneak up and grab you. But the mindset needs to be right now, and this is the new transition over the last couple of years, because most employers are, virtually all, they believe they're good people. They are treating everybody respectfully. They're trying to do the best for their company, their shareholders, their families, and do everything. And then we get this out of the blue other party that doesn't have anybody else's interests in mind, and they just want something for them, and they're going to try to extract it from the employer. Naturally, you're going to be defensive. Naturally, you're going to feel that you want your day to show that this is not true. It's an irrelevant, unjust allegation, and we want to quash this for not only our peace of mind and our business, but for our reputation. And so there's a real reluctance for settlement, which we completely understand. But the mindset right now is, what do you have to lose by settling? And the insurance carriers have this, and they've had this for years. But why don't we just settle and take this away? We're going to be paying this, so why don't we take that approach? And here's the thing: a lot of employers are like, it's a principle. Like I mentioned, they're good people. They don't want their reputation tarnished. They also think that maybe if they settle here, they're going to settle. They'll be settling all over the place, and that's a problem that could open future things. But when you think about it, if you move forward and you deny settlement, which you do have a provision to do within the policies, but if you want to move forward with litigation can open up an employer on a lot of fronts that they weren't counting on, okay, including government investigations. You can have the Department of Labor in the state of California decide that, well, as a result of this litigation going forward, you're now on their radar, and they would like to audit your financials. They'd like to audit your employee handbook and make sure every single page is the latest version of the page. They're going to audit your policies and procedures, okay? And when you have those regulators scrutinizing on every page of your records and so forth, very likely they're going to find something, and that's another distraction. That's additional fines, penalties that may not be covered by employment practices. Not being in compliance with the state on employment issues is not a coverable issue in employment practices. So, do you want the government crawling through your books? Maybe you should think about settlements. Now, there's an issue with regard to, well, settlements, we want to keep this quiet. Well, it's a very common clause with most every settlement, and if it's a settlement under insurance, they will 100% of the time insist on a confidentiality agreement. Okay, so you don't want news getting out about your firm. You don't want bad PR. If you get into a settlement, the other party by law has to keep it confidential. And so, and you can keep it confidential as well. That gives you, the ability to then get this issue closed, settled, and out, and without fear of damage to reputation. Being human beings, yes, there are people that may not go along with the settlement agreement, or through the chatter within a firm, within the ranks of the employees, they'll hear about, obviously something was settled and so forth. Okay, that may get out if somebody is going out there and going on social media and saying, I just stuck it to the man. Obviously, there are going to be consequences for that individual. So you've got some protection there. But the concern on, well, if I settle, everybody else is going to hear about it within the team, and it's going to get out and it's going to be bad. Well, you know what? If you go forward with litigation, those other employees are almost certainly going to be deposed by the plaintiff attorney. And so whatever they may or may not know, they're now going to be witnesses, and they will be even more informed on what's going on. So that's just a whole nother residual effect if you go forward with litigation. And so, you don't need any more witnesses for the other side potentially coming against you. So again, that's why settlement is there. And so the way, these have led to is just this reality that, time is money, and the longer a claim goes on, there's only one way the expenses are going to go. They're going to go up. I would say that a bulk of that average $125,000 cost, a bulk of that is to pay the legal expenses of the plaintiff. Plaintiff attorneys will get paid on their deals because the employer or the insurance company, as part of the settlement, will cover their fees. And so the longer they're working, the more their fees go up. Naturally, that's going to happen. So I would, in summary, just say it's not a great situation, but we have a robust economy. There are people that really want to work. There are people that are, engaged, and employers in California are far more sensitive to the needs, both emotional and financial, and a lot of other things for employees. I mean, California employers are unique in that they are very aware, very savvy on things to make sure that their employees are happy and engaged for the long time. I mean, there are exceptions to everything, but I think that those are out there. So we can see a robust economy coming back to California with a lot of employees. So employment practices is a coverage that's going to be around for a long time, and it's going to constantly be needed because there are situations where it will come up. We're hoping to limit those. So to get proactive and work on the HR policies and procedures, communication with employees to avoid these situations, is really the way to go. I'll ask Tony to chime in on the HR policies and procedures, but I would say bottom line, with COVID, we haven't seen the big spike in claims. It's just the same old stuff. It's just the way you address them now. Settle as soon as possible, and you move on from there. If there were some recommendations, I see we've got a slide there on recommendations. Okay, well, what do we do now? We've got a policy. First question is, if you don't have a policy, run, don't walk, and get one.
Please.
Okay.
Please.
If you go through your PEO or your TriNet or ADP or something, and you have some coverage there, that's better than nothing. I would sincerely consider maybe getting a look at a quote just to see what the option is there, because there are some real tangible benefits to having a separate policy. But it's something I would always say, something's always better than nothing. I would say if you do have an EPL policy, the way you understand it, take a quick look at it and make sure that first of all that it's current. There's, unlike auto insurance and other personal lines, these don't renew automatically, and we have had very sad cases where they thought the policy had renewed and they confused it with their workers' comp, and they went without insurance for 6 months, and then they had an employee termination, and it was really sad, and we had heartbreaking news for that employer. So check the dates. I mean, it's basic, but check the dates. The other thing you really should do is, and it should be easy to find with all the mouse print there, but it should be easy to find. In the event of a claim, there's called a notification provision. Okay, that if there's a claim, there's a phone number and an email address. Get to the insurance company immediately. Okay, and you can copy your broker. Helpful to do that, but I would state that it's probably in your interest to notify your broker and the insurance carrier at the same time. There are some people that rely on the broker. They just send a notice to the broker, and the broker has to do it. That's a delay. Send it to both of them. Okay, and then get those 2 items, and then from there you can always put a call over to your broker, and their job is to walk you through and point things out. But those are the main things there. Just keep an eye on the dates and keep an eye on the amount of coverage. And in the case of emergency, you break glass. Know where that part is in the policy so you're ready to go. Tony, I'll turn it over to you for the other items.
Thank you. So, what we're seeing right now too is obviously we're anticipating the market to get a little hard, whether it be health insurance, workers' comp, EPL, cyber, property. COVID has impacted, the fires have impacted not only businesses, but risk in general. And so we're really trying to promote prevention. We really want our client base and businesses that we work with to have preferred risk, right, Patrick? So if we're going out to the market and everything, but what are some of the things that I see from a prevention side and also from a underwriting as well too? Why are you preferred? At the end of the day, how can I brag about you so we can get lower premiums? And one of the things I see is that policies and procedures. So all the time we'll have questions, and the first thing I always ask is, when was the last time you've updated your policies and procedures? When was the last time you dusted them off as well too? So laws keep changing, and there's a lot of new nuances. So make sure, I would just say, your platform is compliant and up to date, and you're having everybody sign it, and your training managers as well too. What I tend to see sometimes, Patrick, with claims is there's always some sort of trail of tears, and then a claim pops up. And if you don't have leaders and you just have managers, I tend to see that they're not following the policy procedure, they're not coaching and counseling, and they're not hiring correctly as well too. Because most times what I tend to see is these pop up when you make an employment action. You fire people, right? You put them on leave improperly, you furlough them, or you impact their employment. And so really the people that are kind of in charge of that are the managers and supervisors and leads as well too. So making sure that when you have that strong foundation, then you're training your managers, Then also too, you have proper documentation, right? You never want to have anything be a surprise. I'm always surprised to hear, when there is an EPLI claim, my question to them is, or a workers' comp fraud claim, I'll always ask, is this a surprise? And they'll say, oh no, they were horrible. Well, and I go, they were your employee. Well, how long have they been horrible? They've been horrible for 5-10 years. And I go, oh, okay. Do we make them terrible? Did all of a sudden they become terrible? But do we document properly? Is one of the things that it resonates when I look at EPLA claims and how long they go on and how stressful they are, and the amount as well too. So were they long-term employees, but did we not do a lot of performance reviews with them and coaching and counseling? Seek counsel. Whenever you're deciding to pull a trigger, I really do think having an outside person, whether it be myself, a labor attorney, an HR expert, I think it's always great because a lot of times my clients are so close and emotional to the situation. I mean, at this point, they can't stand how this person breathes. And my question to them is, an outsider looking in, would it look fair, right? And I'm usually not attached to the situation, and I'll kind of say, well, I don't think you have enough there. Or on the surface of it, because of timing, it may look like retaliation. I'm not saying you're doing this, but that's how it looks. That's how it feels. And so I think a lot of times before you're going to be, furloughing and laying off, sometimes it is good to seek counsel just to make sure that on the surface of it, it doesn't look like it's age discrimination or just discrimination in general. And also too, you're just very careful in regards to, are we following the procedures? Are we following the policies that we have? And do we have the documentation as well too? Timing is everything, right, Patrick? Timing is absolutely everything. Again, a lot of times my clients tend to make employment actions. Someone's sick, hurt, or ill. And on the surface of it, what does it look like? And I will always say, it looks like retaliation because of the timing, right? So kind of on the surface of it, what does it look like? But also too, timing is so incredibly important when it comes to EPLI claims or workers' comp claims, right? The sooner the better, right? And I think one of the things too, Patrick, is I love it when we have a situation with one of our clients and we can get on the phone and we can strategize and we can really look at the policy and go, this is covered, this is not covered. What does it look like? I really do think timing is critical, having the right team and really understanding, okay, is this legit? Is this fraudulent? Is there any truth to this? How crazy is this person? How long could this be? Is there any teeth to this case here? And really kind of getting together and strategizing as well too. And my last thing too is identifying your risk and preventing the claims. I think we all know, or maybe we don't know, where our boogeymen are. I think we all need to take a deep dive and look at, do we have high turnover? Do we have a lot of layoffs? Do we have, are we paying people correctly? Are we paying them below, what the norm is and everything? Are those some of our risks that could potentially hurt us down the road? And try to engineer those out or work as a kind of a prevention campaign, whether it be, we've had some unhappy employees, we've seen some heavy turnover, we want to work on retention, right? So I really do think for 2021, it's really, really important to kind of have the documents in place, have everybody sign, make sure people are compliant, are also to timing wise, giving those complaints, those issues, feeding that information to HR. I'm surprised how many times HR has no idea someone's not coming in, somebody's high, somebody is harassing, and we don't know what's really, really going on within the in the departments. So I think timing along with the documentation is critical. And I think really looking at your environment, looking at your demographics, looking at your people, looking at your managers and saying, maybe my managers do need coaching and counseling. Maybe they need emotional intelligence. Maybe they need communication skills so that way we don't have kind of runaway train with claims. in regards to EPL as well too. So, those are just some of the things that I've seen recently, Patrick. But, really the goal is to make sure you have the right policy, what's covered, what's not covered. And what I tend to see too is we have a lot of people come to us, Patrick, and they actually have no idea what they have. I then say, would you like us to help you? But in regards to the folks that are here on the call and everything, we'd really like to help all of you. A lot of you that are on the webinar today are our clients, and some are not as well too. But, Patrick, how can we help the folks that are here, just as we're talking about some of the key things that they need to know about their policy?
Yeah, and we talked about this, and so what we wanted to do is just give you a quick review of what you have right now. And so what we would offer is, if you have an insurance policy now, send us a copy, send Tony a copy of the policy. We will review it for a couple of major key items, specifically the amount of coverage you have. If you have this, what we call a hammer clause, where if there's a settlement offered and you disagree to it, there's a punishment if you don't go along with it. Okay, there are others that have a softer approach on it. We could look at that quickly. We'd also look to see whether or not you do have that elusive wage and hour coverage. And we just point out very broad brush. We will not be soliciting business from these. We can't actually comment on the cost at all, because we would need to get the application and the underwriting. And I'm not asking for that. We're just going to look at the policy. Also, if it's a carrier that we're aware of, good, bad, or indifferent, we may give you just a quick little comment on that maybe you could look at that. But we really, something is better than nothing. But if you have something, okay, if there's a negligible difference to tweak it up, we don't want you to cancel it and recreate the wheel. There might be just some little enhancements that can be asked for at a minimum cost, and that's what we'd offer for you. The only other thing I would mention with Tony is, if you do have an incident, don't think, report to the insurance carrier, but maybe talk to a labor attorney and they can give you an idea. Say, well, if you're willing to settle for this much, there's a real good chance, you can avoid all this, you get the settlement. That comment can be very, very helpful, because it's a settlement maybe a little bit more than what the deductible is, but the wear and tear on your soul for dealing with that, and say, well, they want a $100,000 settlement and we could have structured that. No, I'd rather let it become a claim. I'm just out $35,000 for the retention. It's not that simple. And so there are issues that can be taken care of on that. So again, it's one of those that they're fluid. We can work with you, but this is the new mindset out
there. Fantastic. Patrick, thank you so much. I'll be sending out your contact information to everybody. Thank you so much for being on this webinar. We have absolutely no questions. You did a phenomenal job of just educating everybody. I wanted to thank you personally. They have no problems. They have no employees. There you go. One of the things that I love about our partnership is you're an expert in the arena of EPL. And also when we do have a client that has a claim, the partnership, the education, the let us strategize here has just been huge, beneficial. Obviously people have coverage, but it's really when there's a claim is really when you jump into action. And so for all of us at S&K, I wanted to thank you for being such a great partner as well too. Again, Patrick, you need to know if there's wage and hour. If you're one of those dinosaurs and you have an actual, but what does that look like? Hammer clauses, it depends in addition to your limits. What are your limits as well too? And those are all things that you want to know, like the back of your hand, before you have a claim. So if you have to go to the owner or the board, you can say, no problem, we've got coverage and here's what it looks like. You never want to be caught with a claim and going, oh, I wish we could have made some of those changes. Unfortunately, your hands are tied at that point. So thank you all so much for being on our webinar. Patrick, thank you so much again. Amazing partner, stress, but you're able to walk us through, help our clients, and also to prevent, prepare, and if there is a claim, try to close it as soon as possible as well too. So for all of you that are on the webinar, thank you so much for attending. We hope you found it beneficial. Please send over your policy. We want to just kind of give you a quick overview of it so you have kind of a good feeling as far as what you have, and to make sure you have what you need as well too. So thank you so much. I appreciate your time. I look forward to speaking and talking with everybody very, very soon, and making sure we're protecting you, not just at your renewal, but the entire year. We'll talk to you soon. Bye-bye.
There you go. Thank you very much.
Thank you. Bye-bye.